wherever you are hearing the sound of my voice. My name is Janet Fashakin. I am the CEO and Senior Attorney of Fashakin Associates PC. We are located in New York, USA. I come to your way every now and then to sensitize you on ways to bring your loved ones to the United States of America. The last lecture, I spoke to you about how to bring your fiancé to America. Your fiancé is somebody that you intend to marry, settle down with, and live the rest of your life with. Today, I want to talk to you about how to bring not your fiancé, but your spouse, meaning either your husband or your wife, who is abroad to the United States of America. Again, my name is Janet Fashakin, and my phone number is 646-261-6030 if you want to reach me. And so let's get at it, because it's closing time for us here, but I like to drop one or two hints, because let me tell you, there is nothing like living in the United States of America at this point in time in the history of the world, especially if you are a hardworking, honest person who do not intend to come to the United States to commit crime. You can live and you can live large. How can you bring your spouse who lives abroad to the United States of America? Under the immigration laws of the United States, the term spouse refers to a husband or wife who are in a legally recognized marital relationship. Spouses and other direct or immediate relatives or legitimate U.S. residents receive a high priority regarding the issuance of immigrant visas, because America likes families to stay together. Now, how can you sponsor your immigrant spouse to join you in the United States of America? The first step required to bring your spouse to the United States is to file an immigrant petition for your husband or your wife. I call that spouse. Okay? And once you file that form, you can file it. That form can only be filed if you are a U.S. citizen or a legitimate permanent resident, which means you have your green card. Unlike filing for your fiancé, in which you have to be a citizen, if you are filing for your wife or your husband, you can be a green card holder or a U.S. citizen. If you are a U.S. citizen who files a petition for your spouse, it will not be placed on a waiting list. So meaning that the visa is an immediate visa. The law gives special consideration to direct or immediate family members of a U.S. citizen. The Department of State will ask your spouse to apply for an immigrant visa as soon as the U.S. Citizenship and Immigration Services approve the petition using the appropriate form, or Form I-130. Your spouse will receive an immigrant visa number after the form has been approved. Due to the large number of applicants and immigration restrictions, waiting times are often 2 years or more. You can check the visa bulletin from time to time from the State Department to find out what the current waiting times are for your spouse to receive a visa number. If your spouse is outside the United States when the visa petition is approved, and when an immigrant visa number is available, if applicable, your spouse will be notified to go to the local consulate of the United States to complete the immigrant visa process. If, however, your spouse is legally in the United States when the visa petition is approved, which is much better and faster, and because then you can file the form to change or adjust your spouse's status and to legitimize permanent residence. Spouses of US citizens who are legally in the United States can file their petition using the same form that you use for those who are abroad. And in addition, you can file to adjust the status at the same time. And what does that do? What it does is that because you file the form to adjust status at the same time, then your spouse will be able to receive work authorization and parole, which will be able to travel and then she'll be able to work legally in America. And can your spouse live in the United States while your visa application is pending? If you are a US citizen, once you submit the form, the petition for your spouse is eligible to apply for a K3 non-immigrant visa immediately. And this will grant permission for them to come to the US to live and work while the visa petition is pending. So they don't have to wait for the approval of the visa petition before they start doing that. If you are only a legal permanent resident, however, remember that I said unlike the fiancé one, where the legal permanent resident cannot file, in this one, where you are already married, as a green card holder, you can file, and as a citizen, you can file. But the only difference is that if you are only a legal permanent resident, your spouse cannot come to the US to live or work while your visa application is pending. If you file the petition for your spouse when you are a legal permanent resident and you are now a US citizen, you must inform the USCIS immediately so that you can update the second family present petition to immediate family member. Because while you are a legal permanent resident, the category is F2. But once you become a citizen, then it becomes an immediately available visa family member. You can also do this by sending proof of your US citizenship to the National Visa Center if they are abroad by sending the following documents: a copy of the biographical data of your US passport where you have your photograph, the place where you have all those jamboree writings and so on, that is your visa number and so on. That's your biographical data page. You make a copy of it or a copy of your naturalization certificate, and it's as simple as that. Once you do that, they will change the category to that of an immediate family member of the US citizen, and then the process will also take place just the way I have highlighted it. That's an immediately available visa that can allow your spouse to join you here in America, and then once he or she is here, you can then apply for work permit, and you can also apply for parole while you wait for the green card actually to be granted. So if you need help bringing your spouse to the United States of America, or if you have any question about any immigration issue relating to a case that you have submitted, whether for your spouse, whether for your children, whether for work or other related matters, you can always contact us at Fashakin Associates PC Law Firm. Our phone number again is 646-261-6030. You can also contact us by WhatsApp at +1 646-261-6030. We don't take walk-in. We advise that you have an appointment, and by calling that number, you'll be able to secure an appointment. And until I come your way again, I hope this has been beneficial to those who may need it. And maybe next, if this one is not your area, is not something that you need, hopefully next time we will touch on your area of concern. Have a wonderful day, this morning in your area, or afternoon or evening. And from us here in New York, it's evening time. The time now is almost 8 o'clock in the evening. Have a wonderful time. Have a wonderful week. And if you are going through any turbulence immigration-wise, just speak up. Contact an experienced immigration attorney. We do a lot in rehabilitating damaged cases. If your case has been damaged, don't think you are hopeless. Reach out to us. I often say that the law of America concerning immigration is very, very friendly because the founding fathers, they themselves, they were coming from, you can say, tribulation, from persecution areas, and they provided for us situations like that. A lot of these laws are not tapped into. It's not that they are not there in the books. So reach out to an experienced immigration attorney and don't live in despair. Don't live running from pillar to pole because your immigration case has been damaged. Speak up, and also if you are a prayerful type, pray and the Lord will help you. Thank you and have a good evening.